Muted.
Thank you very much for joining us.
My name is
My name is Isaac Ludo. I'll be coordinating the program today. We are talking about maintenance. It's a national maintenance awareness webinar.
We are hosting today at the NPA. As you all know, that maintenance is a very thorny issue that divides families. That breaks.
You've muted yourself, Isaac.
Am I audible now? Apologies for that. We are just sorting out the connection quickly here.
Please ask if they can hear you.
Can you hear all me? Can you all hear me?
There you go. We can hear you now.
Can you hear me now?
Can you hear me now?
Yes, we can.
Colleagues, so that are joining us
online, I'm audible now.
Yes, Isaac, I had indicated that you are.
Oh,
Thank you so much, NPA. Like I've said, apologies for that small glitch. I think everybody should be able to hear me now. Welcome, colleagues, and thank you for the opportunity for taking your time and joining us in this important August occasion of the launch of the NPA maintenance awareness. You all know that you should be able to hear the very chronic issue that divides families, important that breaks relationship, but also of the launch.
So with me here, I've got a
panel of advocates specifically dealing with this. All know that you should be able to hear the very they will be assuring how to divides families, important that breaks relationship, but before so let me first by introduce the leadership of the NPA. Got the panel of guidelines what we all know that we should be able to hear the very they will be assuring how to divide families, important that breaks relationship, but before so let me first by with us introduce the leadership of the NPA. Got the panel of guidelines what we all know that we should be able to hear the very they will be assuring how to divide families, important that breaks relationship, but before so let me by with us introduce the leadership of the NPA. Got the panel of guidelines what we all know that we should be able to hear the very they will be assuring how to divide families, important that breaks relationship, but before so with us introduce the leadership of the NPA. Got the panel of guidelines what we all know that we should be able to hear the very they will be assuring how to divide families, person that breaks relationship, but before so with us introduce the leadership of the NPA. Got the panel of guidelines what we all know that we should be able to hear the very they will be assuring how to divide families, person that breaks relationship, but before so with us introduce the leadership of the NPA. Got the panel of guidelines what we all know that we should be able to hear the very
Yes, sir, I am. Thank you. Okay, good morning to all on the platform today. It gives me absolutely great pleasure to be able to welcome you to the inaugural National NPA maintenance webinar. This is our first one that is run. Thank you. And we are quite excited about today. We are particularly honored to have our National Director of Prosecutions, Advocate Shamila Batohi, as well as to the inaugural Rodney de Kock, who is the Deputy National Director of Prosecutions specifically that is running and we are quite excited about the leadership as well as the inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the leadership as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the leadership as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the Department of Justice as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the Department of Justice as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the Department of Justice as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the Department of Justice as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited about the Department of Justice as well as I know inaugural supporting Rodney National Initiatives Deputy National Director. This is our first one specifically that is running and we are quite excited to educate the public and create more spaces where there can be engagement around maintenance. This particular webinar for us is the start. We are planning provincial webinars, maintenance webinars throughout the country, just to create those platforms to engage with us, the NPA, as much as possible. So to all of you, I hope you enjoy this webinar. It is a first for us. Excuse any of the glitches that may come up, technical glitches and so forth. But I do believe this is the step in the right direction, and it shows the absolute priority that we as the NPA view maintenance and all of its issues. Thank you very much.
Thank you very much,
for that opening remarks. We'll hand over now to the National Director of Public Prosecutions, Advocate Shamila Batohi, to also have a word opening remarks. We'll hand over now to the National Director of Public Prosecutions.
Thank you very much to the program director, Mr. Isaac Lulu, and I also thank you very much for becoming a program director, Mr. Isaac, urgently that he had to. I also thank you very much for becoming a program director today, Mr. Isaac, urgently and the Bonnie Gamble, I also thank you very much for becoming a program director today, I also urgently and the Bonnie Gamble, I also thank you very much for becoming a program director today, I also urgently and the Bonnie Gamble, I also thank you very much for becoming a program director today, I also urgently and the Bonnie Gamble, I also thank you very much for becoming a program director today, I also urgently and the Bonnie Gamble, social services, thank you very much for becoming a program director today. A lot strongly, and in a very focused way at the issue of child pornography and their social need to raise more awareness for the reasons set out by Advocate in order to eliminate child maintenance and other social realities that are faced by vulnerable groups when they seek assistance from our courts in a very focused way. At the issue of child pornography and their social need to raise sexual and gender-based violence and femicide, as a result of which our president has declared it for the reasons set out, and there have been a number of child and other social realities that are faced by vulnerable groups. At the highest when they seek assistance from our courts in gender-based violence in a focused way. At the issue of child pornography and their social and understand sexual and gender-based violence and femicide, implementation as a result of which our president has declared it for the reasons set out, and there have been a number of and other social approach, and it does depend on various the highest when they seek assistance from our plan in a focused way. At the issue of their social and understand sexual and gender-based violence and femicide implementation as a result of which our president has already declared the reasons set out, and there have been a number of other social approach, and it does depend how various the highest when the following seek assistance from our plan and one is that accelerating in a focused way that address as you and their social and understand gender-based violence and femicide implementation as a result of which our president has already declared the reasons set out, and there have been a number of other social approach, and it does depend how various the highest when the following including and one is that accelerating in a focused way that address as you and social and understand gender-based violence and femicide implementation as a result of our president has already declared the reasons set out to eliminate other social approach, and it does depend how various the highest when the following including and one is that accelerating in a focused way that as you and social are not implemented it's never has already taken other social controls it does how the highest when the following including and one is that accelerating when in a focused way that as you they are not implemented it's never has already taken other social controls it does how the highest when the following and one is that accelerating when you have as you they are not implemented it's never has already they are not implemented. 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 They are not implemen lives we never had social justice and also
Identify the processes of applying and receiving maintenance. We deal with a number of applicants who are not educated, and therefore they need to understand the processes, the legalities, and we need to ensure that we communicate in a way that it is understood by all persons. So in order to achieve this, and in line with the high level national strategic plans, the NPA has to work with all its partners, stakeholder collaboration, public awareness initiatives, education initiatives, such as this. Really are critical in order to ensure that we are able to communicate what people can do and how they can get better access to the NPA services in this regard. The Sexual Offences and Community Affairs Unit in the NPA is tasked to deal with and to combat gender-based violence. And one of its sections focuses specifically on maintenance as a specialized field. And, it does not only provide prosecutorial maintenance services, but also the effective and efficient management of maintenance matters, without deviating from the core NPA mandate. And so this launch is really important. And as Advocate Bonnie Curry-Gamore has indicated, it starts and heralds the rollout of provincial maintenance webinars and others even nationally perhaps, aimed at educating the public about their rights and responsibilities in this field, about the processes in the criminal justice system, about collaborating with partners and stakeholders, and also holding each other accountable with the intention of really ensuring that we improve maintenance systems and that we deliver service to our people at the highest levels of effectiveness and efficiency. And the success of this national maintenance webinar rests not only on the NPA as an organization, but as I said, on all partners working as a collective and in the spirit of the purpose of the National Strategic Plan to achieve the pillars that I mentioned. It's really important that all of us try to spread the word, and I understand that the media might be present at this webinar. I certainly hope that they can work with us to ensure that we raise more awareness about this and that those that need access to the services understand what's available, understand how it can be accessed, so that we really enhance the issue of maintenance in terms of the numbers of women that receive maintenance, but also in terms of the speed and accessibility to the services. So I wish you everything of the best in this webinar. I won't be staying for the entire webinar, but as Bonnie Karigamo has said, it has the support of the NPA from the National Director throughout the organization, and we certainly hope that together with you as our partners, we will be able to ensure that we deliver a better service to those that need this. So I thank you very much. Our colleagues will be online to take your questions and other comments. So thank you very much, Program Director.
Thank you, NPA.
It's much appreciated. I think we've said a mouthful. And the colleagues that are joining taking note of your important announcement. The opening remarks are more than enough. And as you go proceed with the program, I hope also that I actually urge everybody to start taking notes and questions, as we'll be able to take questions later in the program. But yes, what you've said, and it talks about rights and responsibilities as well, which ties in very well with our theme today, which is the right of every child and the responsibility of every parent. So as parents, we've got a responsibility for our children. We know that it's not everybody that is able to provide maintenance to the children. Circumstances differ. We should be able to then assist as government as well through social grants and other issues. Maintenance is a social justice issue that is really problematic in our country, but we should be able to, as NPA, we commit ourselves to help those that are in need of these services throughout our provinces, offices, to be able to then consult and be able to be assisted so that they can be assisted to get what is right for their children as well. Thank you very much, NDPP. I will proceed with the program.
Thank you, Program Director. With your permission, may I be excused?
Excuse me.
Thank you very much.
You're welcome. So
thank you, ladies and gentlemen. Thank you for that overall speech that was made by the NDPP. I hope you've all heard. And I've also indicated that we'll take questions and proceed with our program as I've indicated earlier on. And I've got a panel of maintenance prosecutors from various provinces of our country that are with me in this room. So what will then happen, because maintenance is a broad subject, so we'll then trying to unpack, and eat this big elephant piece by piece. So each one will then deal with a specific particular issue that will then add up to the whole issue of maintenance at the end. It's not the complete agenda of the maintenance. We can still add more elements to it, but we should be able to then cover at least the gist of what an ordinary person will need in terms of the issue that as and when the need arises for a particular person to seek assistance in terms of maintenance, the person will be able to know exactly where to go and what is needed going forward. So without really wasting more time, I will then start with my colleagues at the head of this, which is Advocate Refilwe Lekwati. Advocate Lekwati will also give us, an overview of the role of the maintenance unit at the head office, unpack exactly what maintenance entails. So I'll hand over to Advocate Lekwati as soon as she is ready.
You can proceed.
Thank you, Program Director. Thank you, Program Director. Thank you, Program Director. And apologies for that. Good morning, all, and welcome. Thank you to our NDPP and our Special Director of Public Prosecutions who spoke before us and opening this launch. Colleagues, my name is Refilo Lukwati. I am the Senior Maintenance Prosecutor stationed at National Office NPA in Silverton. As we have heard the previous speakers, we are within the soccer unit, within the NPA, and within the soccer unit, amongst other sections, we are focusing on maintenance. So that is why we are launching this webinar to raise awareness around maintenance in the country. Colleagues, I would also like to thank all those who have joined and also our partners. I'm going to share with you and talk to you about the role of the NPA in maintenance today. I think it's very much important for people to know what role does NPA play in maintenance. And this, as we continue, is for people to understand and not to be confused as a result of what NPA does and other government departments in respect of maintenance matters. I would also like to give a brief background for people to understand where we come from. People need to know that, okay, the Constitution, Section 197 of South Africa, empowers the institution of the NPA. That's where we come from. As a result, the NPA itself has prosecutors with the mandate coming from the Constitution to institute and prosecute matters in the courts. Okay, on behalf of the people. Section 197 of South Africa saying that empowers those lawyers. Now, you have heard our national director talking about Section 4.1 of the Maintenance Act. That simply means that every prosecutor is a maintenance officer according to the Maintenance Act. All the functions that needs to be done in terms of service delivery, assisting people, emanates from the Maintenance Act. I think it's important as well for people to know that the Act itself, the Maintenance Act, you have heard our national director talking about Section 4.1 of the Maintenance Act. The national director, that in consultation with the minister, every issue out policy directives according to the Maintenance Act, all the specialized prosecutors to be done to deal with maintenance service delivery. And I'm happy to say to people today that as you see us today, as we are here, raising awareness in maintenance is as a result of the NDPP and also after consulting with the minister that us, as you see us as a special pool of prosecutors, are here and are servicing your maintenance needs. I would also like to also say to the people out there that we are not working alone. We have partners. DOJ is our main stakeholder partner, and also Social Development Office. Everyone is a partner, and as the NDPP has said earlier on, everyone needs to bring their part. As we work together, then we will achieve what we need to achieve and better maintenance systems in our country. I would also like to further share with the people that this, in fact, is an appeal to us all there, the nation, to say we need to take responsibility of our actions. And as we make choices, we need to know that they have consequences and we need to continue and take care of those consequences. For us as NPA and other partners that you expect us to deliver maintenance service, a good maintenance service for that matter. The community also needs to take care of their children. This is a social problem, as the NDPP has indicated, as our SDPP has also alluded to. So it starts with us. It starts with you at home. Take responsibility of everything that you're supposed to be looking after. As soon as you take care of your child, that is a step towards the right direction to start eradicating this scourge of maintenance. Then at the end of the day, the whole country will be in a better place. I would like to also hope that everyone, our colleagues, prosecutors, have also heeded the call and the message from the NDPP to say every prosecutor must also attend to maintenance matters. So with that, colleagues, this is the beginning, as the SDPP has said. We hope to see you going forward and to engage with you more around maintenance matters. Thank you.
Okay, thank you very much,
Advocate Lepati. Thank you for those remarks on maintenance. We should be able to go through a whole lot of other topics today, as I've indicated.
So the next
The
speaker
next speaker will be Advocate Hanedzani Tusa from Gauteng. She will be talking about what is maintenance in general. Advocate, over to you.
Thank you, Program Director, and thank you for this opportunity. I would like to thank or greet everybody, NPA management, soccer management, and colleagues, and also stakeholders. I'm going to talk about what maintenance is. And it is normally said that maintenance is the right of every child and which is the responsibility of every parent. So when you talk about maintenance, it's not something new. It is actually common law duty of support by one person to the other person. And because of people are people tend to ignore their duties, people tend to forget, others tend to reject. Then the government saw it fit that legislation says to be come up with so that it can then force those kind of parents who do not want to take their responsibilities. So when we talk about maintenance, we are talking about provision of certain things, aspect, which is mainly it's about financial support towards accommodation, financial support towards education, and also support towards food, clothing, and medical care. When we talk about legislations, we have few of them. I'm not going to talk about all of them, but the few which I have is maintenance and the Constitution. Of course, we know that it is the right of every child to be supported. Our Constitution, Section 28, put it clearly that every child has a right to a family care and parental care. So that one is just an emphasis towards over and above the Maintenance Act. We also have Children's Act. Children's Act also deals with maintenance of the children. And then in Children's Act, the Children's Court is also given powers to make contribution orders towards maintenance of the child. And those contribution orders, even though they might be made or have been made under the Children's Act, they can be enforced under the maintenance provisions because Maintenance Act is the main legislation. Then the other acts are just emphasizing on what people should do to show that this item of maintenance for the children is very serious. And then we also have got Domestic Violence Act. Domestic Violence Act also defines economic abuse as a form of a domestic violence, which simply means if a parent is not taking their responsibility to maintain the children or any other person, it is actually an abuse which is being directed towards that kind of a person. So that shows that maintenance is very serious. And then we also have our other legislation, which is Reciprocal Enforcement of Maintenance Orders Act. This one deals with maintenance for parties who are not residing in South Africa. In other words, we have one party in South Africa, and we have got another party who is outside South Africa. Those people are also covered within our maintenance legislations, and they can apply for maintenance in South Africa to be enforced across the board. Thank you very much.
Thank you, Advocate Susha. We appreciate that. Colleagues, as I've said, we've got a number of topics. We'll be going through them step by step as we go through the program. So without any wasting more time again, the question arises that where does one apply for maintenance? Advocate Dr. will be able to answer that question. And over to you, Advocate.
Thank you, Program Director. Good morning to my colleagues and to everyone joining us online. Today, I will be informing the public about where they can apply for maintenance. Section 3 of the Maintenance Act, number 98 of number 99 of 1998 is amended, provides that every magistrate court is a maintenance court within its area of jurisdiction. These courts resort under the family court since they specifically deal with family matters as well as maintenance matters. Therefore, a person applying for maintenance must go to the maintenance court in the area in which the person to be maintained resides. They can also go to the maintenance court in the area in which the person in whose care the person to be maintained resides, is employed, or carries on business. This means that the person to be maintained need not physically be staying with the person taking care of them. So the public is encouraged to approach their local magistrate court, ask for the family section where they will be directed to the maintenance section where they will find a maintenance officer who will then assist them with the application. Thank you.
Thank you, Advocate. That was nice, short and sweet. We will proceed, and the next question on our maintenance program is a question that says, who is liable to pay maintenance? And that question will be answered by Advocate Nerita Madiba, who will be joining us in a second. So the question is, who is liable to pay maintenance?
Over to you, Advocate.
Thank you very much, Program Director. Good morning, colleagues, ladies and gentlemen, and those who are joining us online. My topic is who is liable to pay maintenance. And now, before we can talk about who's liable to pay maintenance, there are three requirements that must be met. One is that there must be a legal duty to maintain in terms of Section 2(1) of the Maintenance Act. That is, the legal duty must be on the part of the person against whom maintenance is sought. That person must have a legal duty to pay maintenance. The second requirement is the means test, which means that the person who is liable to pay maintenance must have means to pay the maintenance that is sought. And then thirdly, there must be a need for maintenance. Now, the need for maintenance must be on the part of the person who seeks to be maintained. Then coming to the question, once these three requirements have been met, the question now is who is then liable? Both parents are liable to pay maintenance towards their children. There is normally a perception that it is only one parent, that is the father, who is liable to pay maintenance, but it is both parents who are liable to pay maintenance, and it is according to their respective means. Then again, grandparents and are liable to pay maintenance for their grandchildren. Remember, grandparents can be joined in an inquiry only once the parent is unable to pay maintenance. So it is not automatic that the grandparents will be joined in an inquiry, but it is only when one of the parent is unable to pay the maintenance. And also we have collaterals, brothers and sisters. That is, brothers and sisters can claim maintenance against each other. Also half brothers and half sisters. Then we have another group. If you legally adopt a person, a child, then you are liable to pay maintenance for that child, be it a legal adoption or a customary
already been indicated, is presumed to be the maintenance court of that particular jurisdiction. So approach the court. In our courts, we have got maintenance investigators whose sole responsibility is to assist us to trace the people who are responsible to pay maintenance, and those wherein we find that the person, the applicant does not know the whereabouts of the person. When you arrive at the court, you must ask for a maintenance section, and you will find the maintenance clerk. The maintenance clerk will help you to open your file. Please provide as much information about the respondent as possible. The fact that you don't know the whereabouts of the person who is liable to pay maintenance, you still have to have other necessary information like the last known address of the respondent, at least the ID number or the date of birth of the respondent, his full ID number if you know, the last workplace of the respondent, his cell phone numbers, his car registration number, the email address, if any, his or her social media accounts that you know of. If you have got any of this information, you don't have to have all this information that I've just indicated, but if you know any of this information, please approach our courts, and our maintenance investigators will be in a position to help you to trace the respondent. If you say you know the last, you know his cell phone number, our maintenance investigators will go to ITC and they will help you to find, to try and trace the last known, the present known addresses of the respondent. I would like to thank everybody. Thank you very much.
Thank you, Advocate Palane, for that short and swift message. So the question to an applicant is that once you have identified a person who is supposed to pay the maintenance for the child, there's the process of identification that is involved, and that process involves documentation that you need to bring forward so that you can get this. So the question that we have on our program says, what information or documents are needed for a maintenance application? So Advocate Motley from the Northern Cape will be able to assist us with that question.
Thank you very much, moderator. Good morning, colleagues, our stakeholders, and our community who join us on various platforms. My name is Shamila, Senior Maintenance Prosecutor, Northern Cape. Mine is just to indicate the documents that are required in terms of making sure that your application is successful in the maintenance court. I must indicate that this requisition of documents is applicable to both the applicant and the respondent, meaning male and female. The first thing that we have to do is just to identify the person you are dealing with. So the first document that we will require is an identity document from the applicant who's going to make an application before the court. And secondly, if you don't have an identity document, we are going to require a passport where we'll be able to be identified. We are going to require certified copies of birth certificates of children or a child if it's one. We are going to request 3 latest bank statements. We further require 3 months proof of income, meaning pay slip or a signed letter from an employer confirming the income. We are also going to require the physical address, as Advocate Palane has indicated that sometimes we don't even have that, but our investigators will be able to assist us with the last known address. We are going to require a list of income and expenses, meaning the water and light bill, till slips, groceries, school expenses, medical and clothing accounts. We are also going to require the full name of the person responsible to pay maintenance. Sometimes we don't have that information. However, because this government is committed to assist our vulnerable groups. Our maintenance investigators will be able to trace the person responsible to pay maintenance. We are going to require a copy of a divorce decree if there was a divorce in place before you make an application before our court or for enforcement of that particular divorce decree from the High Court. What is required in terms of the inquiry? The respondent will be required to bring the identity document, as much as the applicant was required as well to pass the driver's license if the ID is not available, the 3 months bank statement, the 3 month statement from the respondent as well, the proof of physical address. We are also going to require the list of expenses from the respondent as well. And as much as we require those expenses from the applicant, we'll require that from the respondent. In instances where you are not going to get them, the maintenance officer can issue Section 8, where information will be coming from the banks in terms of the investigation going forward. We are going to require a copy of a maintenance order if the respondent has a maintenance order in a different court. We'll require that kind of information because it's going to help us to arrive at an order that we think the respondents will be able to afford it in terms of the expenses. We are going to require birth certificates or biological children of the respondent as to whether he has other children in different courts, so he can be able to guide us when we conduct our inquiries going forward. One thing that I want to emphasize is the fact that our public members, if they don't have specific information in relation to their whereabouts or any information that is required in court, they can approach our maintenance officers who are always there to assist them. We know very well we don't have maintenance officers in all the courts. However, we provide information as is required, and we also make sure that our clients are assisted. And from our side as NPA, I think going forward, we'll need stakeholder collaboration as we work very closely with the Department of Justice. We'll also require our NGOs to be involved in maintenance setup so we can be able to assist our vulnerable groups. Thank you very much.
Thank you, Advocate Malawi. That was wonderful. Our colleagues that are joining us, please post question on the chat. We should be able to the program. So the next question that also relates to our maintenance issue talks about can maintenance agreement be verbal or written between participants and can it be forced? What advocates can find Advocate John Waiters from the Western Cape will be addressing that question. Can a maintenance agreement be verbal or written? Advocate participants and force calling for the floor. That's our next topic. Over to you, Advocate John Waiters.
Good morning, Program Director, as well as the members of public joining us today. Mine is dealing with the written and verbal agreements in terms of Section 6 of the Maintenance Act. The maintenance legislation do provide for written and verbal agreements in Section 6(1)(c) of the Maintenance Act that says that these written and verbal agreements dealing with maintenance obligations can be substituted, can then be discharged in the maintenance courts. So there is a statutory provision that do provide for the maintenance legislation in our country. The only problem is the enforcement of it is a little bit tricky when we deal with these type of maintenance obligations. Even though in the contract, civil law, the written and verbal agreements can be enforced in the civil court, it's a little bit more difficult when it comes to the maintenance obligations that is in a written or verbal format. In order to make that specific provision of your contract or agreement between the parents enforceable, it is important that our members of public know that they can then apply for a maintenance order to be made that is either going to substitute the current maintenance agreement between the parties, or else then to discharge that maintenance obligations that were done via a written agreement or via a verbal agreement. Section 1 of the Maintenance Act is clear that a maintenance order is an order made by any court. So, in order for the public to ensure that that specific written or verbal agreement is enforced, it is better for them to have it in the format of a maintenance order to be enforceable. Section 16.2, my colleague, Advocate Tusha, touched on it, as well as my other colleagues, can be enforced in any court, domestic violence, emergency monetary relief order, or any of the other provisions in where we can enforce those orders. I quickly also would like to just touch in my 4 minutes on Section 33 parenting plans. Susha mentioned the Children's Act, where we deal with Section 33, subsection 3 parenting plans that can also include a maintenance provision. As far as these provisions is concerned, the Children's Court will have the authority to make those specific maintenance agreements that is in a parenting plan and order of court. So these days, even mediators can now conclude these type of maintenance agreements. So it's important that the Children's Court will then make these orders enforceable in our Children's Court or in the Maintenance Court. I also would like to note to the mediators that once they concluded any type of agreement that have been reduced to a parenting plan, that written concluded agreement should be made an order of court, or else it should be registered by the Office of the Family Advocate in order to make that specific provision then applicable. So written and verbal agreements can be enforced if we make it an order of court in the maintenance courts. Alternatively, other types of agreements that include maintenance, whether it is the Children's Court, Section 33, subsection 3 parenting plans, registered with the Office of the Family Advocate, and make sure that your order is then made an order of court. I thank you, Program Director.
Thank you, sir. Much appreciated. Advocate from the Northwest will taking us through the different types of maintenance orders that can be granted by law. She will be giving us in a sec. So that is the question. What type of maintenance orders can be granted by a court of law? So Advocate will go and discuss that.
Thank you, Madam Director. Good morning, colleagues, and everybody joining us online. Yes, I'm going to talk to you about the type of orders that the court can make, or maintenance court can make. After the inquiry in terms of Section 10 of the Maintenance Act, the court can make a new maintenance order. That might include a stop order, an order for medical expenses, and also an order for the person legally liable to be maintained, be joined as a member under medical aid. Then the court can also make a maintenance order for the lying-in expenses of the mother. That means it is the expenses incurred during pregnancy, and includes also maintenance for the child from birth until the date of order. The court can also make an order substituting the existing order if there is an existing order. The court can also discharge that order if there is an existing order, or make no order. It's important to note what my colleague said at Reuters, that if there is a verbal or written agreement, the court can make on application a substitution order of that verbal agreement, or discharge the verbal agreement. Important to note at this stage that the court can make an interim maintenance order before the inquiry in terms of Section 10.6. This is where the postponement of the inquiry is necessary and the court is satisfied that undue hardship will be suffered by the person to be maintained. Then the court can make a garnishing order in terms of Section 16.2. This is basically an order directing the employer to make on behalf of the employee periodical payments. This order will have the effect of an emolument attachment order. Important to note that in the judgment Soller versus the magistrate of Weinberg, the maintenance court, or the court says the maintenance court are fully empowered to make orders relating to the periodic payment of future maintenance from pension funds. Then, in terms of Section 17, the court can make an order by consent. This is if both parties agree, not necessary for them to be present at court if they sign Form 214. Then the court can also make an order by default. It means if the defendant or the respondent is not present at court, the order can be made in his absence against him. Then the court can vary certain orders on application of the maintenance officer. That will be where banking details, etc., can be varied on the existing order. Then the court can make certain cost orders for the service of process. The court can also make certain cost orders relating to paternity tests, and this includes a provisional order directing the state to pay the whole or any part of such cost. Then I'm just going to mention Chapter 5 orders. This is the orders for the recovery of arrear maintenance. My colleague will deal with it in full. Is emolument attachment orders, the warrant of execution, and orders by debt. Then lastly, the court can make certain orders relating to prosecutions in terms of Section 40 of the Maintenance Act. The court can, after a conviction in terms of Section 31, grant an order for the recovery of any arrear maintenance from the convicted person with interest, and this order then shall have the effect of a civil judgment. Thank you.
Thanks so much, Professor Zaid and Ruth. That was a mouthful. We are still talking maintenance and gentlemen for So then the question arises, how they
the person who's appointed the responsible is what Advocate Stephanie Erasmus from KZN to unpack the particular issue. Thank you, and over to you, Advocate.
Good morning, everyone. Thank you very much, Mr. Program Director. I appreciate the opportunity. What do one do? What's your options if the person responsible to pay maintenance no longer complies with the order? We have 4 options. The first 3 is recommended more often than the last because of the fact that should they succeed or be successful, so should one be successful with them, then that will have the monies owed to her in a relatively short span of time, whilst the latter one, which is criminal prosecution, might be dragged out over a period and is maybe less successful. With regards to the civil execution, there's 3 various things that can be done. First and foremost, if an applicant reports to the office of a maintenance officer or to the court, the maintenance court, that maintenance order has not been complied with, then the maintenance officer more often than not will recommend that an emolument attachment be done on the salary of the respondent. rather than anything else. That is usually the quickest and the easiest method to have maintenance order complied with. Other than that, there is also the opportunity to have an attachment done from any debt owed to the respondent. Now, debt in the sense that there's money owed to the respondent by a third party. This third party can be someone, for example, where a respondent has sold a piece of land and is waiting for payment via attorneys of that amount. It might be an investment that the respondent has done, a savings account that is holding, retirement annuity that has been paid into over a period of time. All of those can be accessed and arrears maintenance can be attached from this. In this sense, it's very important that the applicant bring any knowledge that he or she has with regards to the existence of these debts to the attention of the maintenance officer as soon as possible. Understandably, people do not always have that knowledge, and in that sense, the maintenance office and officers and investigators can assist to have money matters of such a respondent that has not complied with his court order for some time investigated, with the aim to unearth such monies that might be existing on his name. There is a third method, and that is the warrant of execution against property, which can also be done. It has its own peculiar intricacies and sometimes might not be successful. So in a normal run of the mill, we would rather recommend that an applicant applies for emolument attachment or attachment of debt. All of that having been said, if we are unable to find such monetary values on the name of the respondent, we will definitely have a look at public prosecution or criminal prosecution rather, in terms of Section 31 of the Maintenance Act as well. In fact, that can be done together with an attachment of a debt, or emolument or warrant of execution. There's nothing keeping us from going both routes. However, it is recommended that the applicant exhaust the attachment procedures first before going to criminal prosecution. Criminal prosecution then will be pursued via the prosecutor, and in that sense, the maintenance prosecutors and the criminal prosecutors will work hand in hand with regards to investigations of the matter and to take it to court. Thank you very much for the opportunity.
Thank you, Advocate Zemo. That was quite interesting. There is something called future maintenance. First time I come across it. It sounds quite interesting when I think it's around here. Which shows that what is the responsibility to take care of our children is that up to the age of 18. So there's no running away more than anything else. So we have advocating the requirement of Mapanda who will be able to unpack for us the issue of future maintenance.
Thank you, Program Director, colleagues, fellow South Africans, good day all. Future maintenance. The meaning of future maintenance refers to maintenance payable in the future. This is done to assist parties who receive maintenance from another party when that party decides to resign for employment prior to his maintenance duties having fallen away. Now, this phenomenon is neither a product of the Maintenance Act nor that of legislation, but it comes from court practice. In other words, it comes from judgments. Our courts have developed this in order to secure future maintenance claims for minor children where such claims are threatened, whether the the recalcitrant parent is in arrears or not. This is when court can draw an inference that a person legally liable to maintain will not be able to meet future maintenance obligations. Now, in most instances, it's pension monies that get attached. Otherwise, in some instances, any available funds may form the object of attachment, e.g. proceeds from sale of a house. The preconditions are that there should be a maintenance order in existence. There must also be a history of the defendant defaulting in making payments. There must sometimes be a tendency by the defendant dissipating his monies in the bank accounts. That will be observed, of course, when that is presented to court. How does one apply for future maintenance? The applicant will approach the maintenance court where she or the child resides, or sometimes where she works. The maintenance officer is supposed to assist with the proper calculations for future maintenance, taking into consideration all future needs of the child. This will form part, of course, of the allegation that she will put in her affidavit, which she has to be assisted by the maintenance office, particularly the maintenance officer, in which she will indicate that the conduct by this defendant is threatening the future maintenance of the child. She must state in her prayer that if nothing is done, the funds will be dissipated and the child will suffer. She must pray to court urgently to freeze the monies in the pension fund or in the bank account. This is made, of course, to secure future maintenance payments in favor of the child. It should be remembered, however, that this money in the bank or in the pension fund belongs to the defendant. It's not due and payable. In some instances, court will make that order that it should be kept in favor of the child in some instances. The party, the applicant, will approach the court. It's called an ex parte applicant. It's one party, complainant, or the applicant that will approach the court. And the other party will not be there. So it's ex parte. She will have to have an affidavit to support her stance. She will have to cite all the parties as to what they have to do and not have to do. For instance, that she demands maintenance from the defendant, who is now respondent. That will be first respondent. What the bank has to do is to freeze the money, or the pension fund has to freeze the money. The magistrate office has to keep the money until a determination is made as to future payments. Now, because this is done by this party alone in chambers with the magistrate assisted by the maintenance officer, the other party who is not there must be given a date on which to contest this. So this is a rule mice order, interdicting the other parties. Now, that done in the absence of the respondent calls upon the court to make this a provisional order pending a finalization of the matter. That is the first order. The second order will be on day 2 or whatever date that has been appointed as the return date. On that date, that first order either gets confirmed, amended, or set aside. This then becomes the second order and it becomes the final order. I thank you, Chair.
Thank you, Advocate Ndamleli. From Makanda, thank you so much. I really appreciate it. And the last topic we have on our program, ladies and gentlemen, relates to the question that says, what happens if the person that is responsible for maintenance passes away? When the person passes away, it doesn't mean that the responsibility to pay maintenance sort of fades away as well. Let's allow Advocate Mohadi Makata, all the way from Mpumalanga, to be able to share and explain to us what happens in this particular issue. Over to you.
Thank you, Mr. Program Director, and everybody who's joining us online. The question is the deceased maintenance liability after death. What is the process thereafter? When the person against whom an order has been made is been deceased, his maintenance obligations will be pursued in terms of law of wills and estates. And in terms of law of wills and estates, the deceased estate will be open for 30 days. That is for inspections. That is the period within which it gives the creditors and the debtors the time to bring in their claims. That is in favor or against the estate. And that is the period within which maintenance application or claim should be brought at this instance. And that claim under the estate where the estate is intact, that is for a period of 30 days inspection. It will be a claim against the executor. So, under that application, because the estate is intact, there will be a certain sum from the estate capital that will be set aside to discharge the estate indebtedness to the maintenance recipient. And if the estate is being wounded up, then the claim that will follow for maintenance, it will be based on the money being paid, not the money being owed. Which means it will be an application to prove undue enrichment from the heirs. That will be an application to be brought against the heirs. So, under that application, the applicant needs to prove the overpayment of the money. And upon successful application, the amount to be paid will be the amount justified as an overpayment in terms of liquidation and distributions of the wills and estate law. Thank you so much.
Thank you so much, Advocate Makata. Thank you so much. I really appreciate it.
Thank you. Thank you.
Yeah, from what he has said, there is no escape this maintenance. Even in death, it follows you. So, yeah, fortunately, we need to then do the right thing and make sure that we really take care of our responsibilities. Ladies and gentlemen, we have formally come to the end of the program. We'll allow now time to those that will pose questions. We literally need to finish at 11:30. Actually, we're planning to finish at 11:30, so we've got at least 10 to 15 minutes to take questions. We've got those that have put them on the chat. I will read them as they are, and then our colleagues will then take them up and then try and respond. To those that won't be able to respond to questions, please send them through to us with your details. If you can drop them an email to media@npa.gov.za, we should be able to respond to them either today or tomorrow. But actually, in secondly, be able to respond to media@npa.gov.za. That's our email. Send any question there, but we won't be able to take it because of time. So yes, let me go through and check things here in terms of the questions. There is a question from Peter K. Manamela. And the question says, why must the grandparents be liable for maintenance? Why must grandparents be liable for maintenance? Felix, I guess you can take the question and respond on your person without any particular order.
Take that one.
Okay.
Thank you. The question is, why must the grandparents be liable for maintenance? Remember, in my presentation, I said there must be a legal duty. That is one of the requirements of the 3 requirements that I mentioned. So, in terms of that legal duty, grandparents have got a legal duty to maintain their children. And that is based in a case law that we have, which is Peterson versus it's a Peterson versus Maintenance Officer Simonstown. But remember also I said it is not automatic. You start with the parents first, then it is only when the parents cannot afford to pay maintenance, then you go against the grandchildren. So you are saying, why are they liable? Because they've got a legal duty. And also remember, they must have the means to pay, that is the grandparents, they must have the means to pay the maintenance. So that is why the grandparents are liable, because they've got a legal duty and because we've got that case of Peterson versus Simonstown that we refer to when it comes to grandparents. But as I said, it is not automatic. You start with the parents first. Thank you.
Thank you so much, Advocate, for that particular answer. The next question that I have on my charts here, just a minute. Go up. There's a question that says, why should a wife be liable for maintenance to the husband's children? Why should a wife be liable for maintenance to the husband's children? I guess it's the children that she doesn't bear. So yeah, maybe if you can get an answer, colleagues.
Good morning. In terms of the law, the wife, in terms of the law, the wife is not responsible to pay maintenance of the stepchildren. So there is no way that we will then call the wife to come and pay maintenance for the children who are not hers. So when you talk about the husband's children, we take it that you are talking about kids who are not these wives. Thank you.
Thank you, Advocate. Short and sweet. Next question. How does a child over 18 years claim maintenance if he is still a student? How does it, Advocate, over to you.
Okay, Ms. Morakile, that's quick and easy. When the child is 18 and still a student, it all depends where the child is living. If the child is living with the custodial parent or what the case might be. In July last year, the Supreme Court of Appeal found that mothers can apply for maintenance. So the child over the age of 18 do not have to apply himself or herself. The mother can still apply for maintenance on behalf of the 18-year-old or the adult child. Also, later in October of last year, in the George Circuit Court, we had a case where the 18-year-old's position was also then discussed by the High Court, where they found that mothers can still apply for maintenance of the 18-year-old. So it's not a standstone rule that 18-year-olds must apply on their own behalf. They can allow their parent or the custodial parent to still apply on their behalf if they don't feel they have the maturity to be in court or want to face the adversarial side of court. So it's not in all cases that the 18-year-old have to claim, but in a case where they feel like it, then they can complete a J101 or J107 form that is on the Department of Justice's website, and they can then apply on their own behalf if they feel they've got the maturity to face the court system. But if the person's a student, stay out of court. Either let your mom or dad go and apply for you and focus on your studies. That is what the NPA would advise you to do. Thank you.
Thank you, sir. Next question from Angel Patha says, if the debt has no assets or bank accounts on his name, and he is a lawyer and has page 7, why is the court not letting him? When I have a court order and all the evidence on the magistrate court. The debt has no assets or bank account on his name, and he is a wealthy lawyer, and has not paid maintenance in 7 years. Why is the court not prosecuting him when there is a court order to that effect?
Yeah, I'll answer that too. Angel, in a case, I say it's Angel Porter. I'm not in any way being disrespectful to calling you Angel online, but it's just that I see it's Angel Porter that asked the question. In a case like where the dad is a lawyer, there was a case a few years ago, Butcher versus Butcher, where a son took the children of a wealthy lawyer took the father to court. So all you need to do is file a complaint on a J470 complaint form, and then we will be able to then prosecute the matter. In a case where we would like to get civil attachments, then we do it on a form that we call a J6, but there are case law that says that there's nothing we can.
Please advocate. Unmute. We can't hear you.
Question. Oh. Couldn't hear you.
Yeah.
Oh, apparently you are not audible, Mr. Directors.
Okay.
Wow, everything I said. But Steph can be audible. Yes, Stephanie.
So it was muted. It was muted. Anyway, it is a case. Maybe let her respond because it's from.
Funny, you didn't respond.
It's from.
She wants to respond. Oh, okay. Yes.
That's it, madam.
Good morning again. Thank you very much. The question is about the lawyer who seem to have the money but then cannot be prosecuted. Certain cases may be a little bit difficult to address and others may be complicated than some cases. So in this case, it looks like it's a matter of which is occurring or happening in Gauteng, but then it can be referred to me. I'm not sure if I have this matter with me, but then the process is that investigations have to be done until such time when we can prove. Because if you talk about prosecution, we need to prove that each time when the respondent or the accused did not pay, he had the means to pay. So in many instances, you find that those kind of means are not clearly visible, if I can put it that way. Those means or assets and wealth and everything might be hidden under other people's names, which then it will mean that we need to have a link to show that though those properties or funds are not in the accused names, they are actually his monies or his properties, and then the court will then make a decision. So it doesn't look like it's a simple case to attend, but it can be attended. So I encourage you to bring it to court or to my attention, and then I will check with the local officers how far they've gone with the matter, and we can take it from there. Thank you very much. The next one, I'm advised that I must talk about the next one. I'm sorry, I don't have the questions on my screen. I was talking about. Okay, there's one matter. I see Ms. Mahlangu, she is asking about a case, and it looks like she has met with colleagues at the court. Fortunately, with this one, it did come to my desk. I had it around January this year. And from what you are saying, you are being assisted. It's only that it hasn't reached the point where you were expecting it to be. And I think we can continue looking at the case. I don't have your, can I just say is it fine? Okay, apparently it's fine. We're running out of time. Thank you very much.
Thank you, colleague. We won't be able to take all the questions, colleagues, like I've indicated earlier. We are actually out of time as we speak. Those that have posted questions, we should also be able to pick up. If you can, maybe share them also on our email address so that we are able to respond directly. We should be able to do that in the next day or so. And thank you, everybody, for joining us. The questions are many. We won't be able to take all of them, unfortunately, online, but we will certainly be able to respond to all of them. I'm at the last item on my agenda, which is the announcement and the next event, which will be done by Dr. Mkhuseli Jokani from National Office. It will reach us. Dr. Jokani, it's over to you, sir.
Thank you very much, moderator, Mr. Lulu. Let me take this opportunity. No, I'm not, Mr. Lulu.
Can't hear you, Dr. Jokani.
Can you hear me? Can you hear me, sir? Can you hear me? Hello?
Yes, we can.
You can hear me. Okay, thank you very much. Thank you very much, moderator, Mr. Lulu. Let me take this opportunity and thank the program director for directing this program very well. And we are on point in terms of time. And once again, I would like to take this opportunity to thank the partners, the stakeholders who have made this particular event a success. You know, particular appreciation to the leadership of NPA for pledging their support, you know, in ensuring that the profile of maintenance in South Africa is raised through this platform. Thank you very much. And I would like to take this opportunity also to thank, you know, the communication of the NPA for providing technical assistance, you know, to the team that was organizing this event, and more particularly special thanks to Advocate Lakwati, you know, and her team for presentations that were well done. Thank you very much, colleagues, and also to our special director, Advocate Kari Gammo. You know, thank you very much for the innovation by making sure that you continue to make, you know, the footprint of the soccer unit, you know, in all the corners of this country. And once again, thanks to the members of the public who have joined us online. Thank you very much, colleagues, for this event. And I'm told that this is not the end, but it is the beginning of more events to come. And I do want to announce that the next webinar that will be taking place will be on the 4th of August in Limpopo. So we would like to take this opportunity and encourage members of the public to ensure that they support this initiative, because we are in a process of ensuring that we are raising the profile of child maintenance, because for quite a long time, child maintenance seemed to be right at the periphery, you know, of the criminal justice system. It's high time that we raise this profile. Once again, big ups to Refilwe Lekgoti and the team for ensuring that this has been a success. And more importantly, thanks to you, Mr. Fubu, for directing this program. Thank you very much, colleagues.
So, thank you, ladies and gentlemen, members of the media, strategic stakeholders who have joined us this morning. We really appreciate your time, and we hope that next time when we host the second one or the other ones that will be coming through, you should be only joining us, especially because it's one of the provincial ones. So each province or region will be having their own seminar, webinar, and then so that they can tackle the issues that are on the ground. But from my side, thank you for all the prosecutors that have joined us here today, the leadership of NPA and everybody who joined us.